My name is Bush Nielsen. This is the fifth video in a series that I've produced today having to do with closing protection letters and the lender's requirements of title agents in order for them to remain on the lists of approved closers. In this video, what I want to talk about is some of the practical issues that exist in those states that have adopted closing protection letter laws in which the title insurer is required to issue letters to lenders, borrowers, buyers, and sellers. The first issue that I have been asked about a lot is who issues closing protection letters when more than one title company is involved in the transaction. So the laws are not perfectly clear and the custom could vary by state, but here are the usual rules. When there is a purchase transaction and one company will issue an owner's policy and the other will issue a loan policy, then the title insurer for the agent that will issue the loan policy issues a CPL to the lender. The title insurer for the title agent that will issue the owner's policy issues the CPL for both the buyer and the seller. On a refinance transaction, the one title insurer will issue letters to both the borrower and the lender. There's another question that I've been asked frequently, and that is when closing protection law is adopted, which requires the title insurer to charge a fee for closing protection letters, does that change the level playing field for closings so that it becomes more expensive for a person to close with a title agent than with the branch office of a title insurance company? And the simple point is that if, for example, it will cost $75 to have closing protection letters issued if the closing occurs with a title agent, but that same $75 charge does not occur if the closing is held at the branch office of the title insurer, isn't that a competitive advantage to the title insurer to drive business to its branch offices? Well, this is a good question, and here's what the title agent should do, which is very important. Make sure that if a law is adopted, it says specifically that the title insurer must issue closing protection letters on all transactions, including those in which the branch office of the insurer will conduct the closings. Now, some would say that a closing protection letter isn't really needed in those transactions where the insurer will do the closing at its own branch office. But most of the laws that have already been adopted do say that the title insurer must issue CPLs in every transaction, including closings at its own branch. That solves the issue about whether or not there is a level playing field. And by the way, the Illinois law that has served as a model for a lot of these laws says specifically that the title insurer must issue CPLs on branch closings. There is another common question about closing protection letter laws, and that is how exactly does the regulator or how do the title insurers figure out how much should be charged for these letters? And many of these charges have been built into the laws. In Illinois, for example, and in a lot of other states, $25 is charged to the lender insured and $25 to the buyer insured on an owner's policy and $50 to a non-insured. That could be the borrower on a refinance loan or the seller on a sale transaction. Those laws say that more is charged to the person who's not an insured, by the way, because there is no premium being received from that person to pay for a title insurance policy for that person's benefit. So in other words, the CPL is the only risk to that person, and a separate charge is made in a higher amount. Now, the advantage of having a fee built into the law is that the fee is uniform throughout the state, and it is uniform in between the different insurers, so that there isn't any way to have a competitive advantage between insurance companies based on the amount that they charge for closing protection letters. The disadvantage is that when the fee is set by the law, it's very difficult to know if the amount of money received by the insurer is more or less than adequate to pay all the claims under a closing protection letter. I believe that everyone would agree, including title insurers and legislators, that the idea of these laws is not to turn the issuance of these letters into a profit center for the title insurers. But how does one figure out if this is a profit center? Now, once a fee is charged and the insurance department in the state has the authority to regulate those charges and to monitor, it can also collect statistical information about losses that are paid under these closing protection letters. Over time, the commissioner should be able to figure out if the fees charged roughly match the claims that are paid out. However, CPL claims are a little different than most kinds of insurance. If an auto insurance company wants to charge a certain amount for a fender bender type accident in a certain city, it can rely on a huge body of statistical information. There are lots of fender bender accidents. It costs a certain amount to fix a car in every place. Those are standardized charges that the insurer has already collected a lot of information on, and this kind of thing happens all the time. Property and casualty insurers have a much harder time trying to figure out how much to charge for protection against tornadoes or floods or other kinds of storms or acts of God. Because you could, in a certain city, you could have a flood one year that is disastrous and cost billions of dollars for the insurers to pay. And then there may be no flood in that city for the next 5 or 10 years. So it's very hard for the insurance company to know how much premium should be charged in order to pay all the claims caused by the flood or lightning or a tornado. A CPL type claim is the same kind of risk. It is, I think it's most akin to a tornado or lightning. This lightning strikes in a very specific place. It affects very few people, but it is catastrophic to those people. Also, this lightning may strike in 1 year and then not strike again for 3 more years, at least with that particular insurance company. So how does the insurance company know how much money it should collect each year in order to cover the loss that it will suffer once every 3 or 4 or 5 years, particularly when the loss could be $100,000 in one circumstance, or in another circumstance that is notable, $75 million. And there have been a lot of losses that have been more than 1 million. It's very difficult to know how much the loss will be. So it is very difficult for insurers to figure out this number. The best thing that I can suggest to everyone who's in the title insurance business, as well as regulators and legislators, is that some method be adopted to try to figure out statistically over time whether or not the charge that is set is adequate or inadequate. Now, I've also heard another common assumption about CPL claims, and that is regulators have said regularly that they think that the CPL claims were actually caused by the real estate crash, and that if real estate is on the rebound, and if it does not crash again in the future, then there probably will be no more CPL claims. The connection between the real estate crash and CPL liability, however, is not a straight line like that. In fact, it's a much more indirect relationship. More escrow thefts were discovered after real estate crashed. And for this simple reason, if I am a title agent and I am doing a lot of closings in a week, I might have $5 million in my escrow account every single day. I can steal $1 million from that account and yet have all the checks and all the wires from that account honored, so that no one knows that I've stolen $1 million from that account. But if the amount in my account goes down to $1 million a day because I'm not doing hardly any closings anymore, then it's kind of like that rocks on the surface or the bed of an ocean that become exposed when the low tide comes. So as the amount in the escrow account goes down, then the effect of the theft becomes apparent, and at some point a check is returned as NSF or a wire transfer can't be made because there's not enough money in the account. So the actual effect of the real estate crash was to cause people to discover thefts that had already occurred when real estate was going great guns. Also, in a lot of cases that are coming up now in the year 2015, the theft began after real estate began to recover. So the two things are not at all related. In fact, the most important factor having to do with theft from escrow accounts is not the health of the industry or the amount of real estate transactions that are being closed, but the reason why the person is stealing the money. And that normally has nothing to do with the health of the real estate business. Most escrow thefts occur for two very sad reasons. The first is that the person has a gambling addiction. The second is that the person has a drug addiction. Those two things require lots of money, and so that person will take money from the escrow account because he or she is addicted and requires a whole lot of money that he or she doesn't have. So the effect on the escrow account has to do mostly with the health and the particular conditions of the person stealing the money, not the industry. All right, I've given you my thoughts on how the closing protection letters affect title agents directly. I would ask that you look at the rest of the videos that are in this series. Thanks very much for watching.